Hi there, I'm Clifford Bates, and welcome once again to reading Schmitt's Dictatorship. Today we're looking at chapter 6, which is the final part of the book. I'm probably not going to be looking at the appendices because they're too specific in terms of law and not really useful for political theory in that sense. Um, and that's why I kind of, I was going to do them originally, but maybe I'll do them in the future. Uh, but I'm going to be looking. We're going to finish up this section on this, looking at part 6, chapter 6, so the dictatorship in terms of contemporary law, which he focuses on the state of siege. Now, this is going to be divided into 5 parts. This is basically over 31 pages long. And if I read it, we'd be here by I decided to break up into more manageable parts. Last time we were getting kind of good in that part because we got 30 minutes, like 30 minutes, 40 minutes. We broke under an hour at the other parts. Um, so therefore, this is like 31 pages, so 5 parts. Today, on the first section, the first part, we will be looking at page 148 to 154. So the state of siege. While the commissars of national convention were designed to eliminate the current organization of the state, the current state of the Aristotle regime, right, and numbers of institutions were established at the same time with the purpose of protecting the current order against the coup d'etat, right, in that sense, um, that there were some new institutions of this that were created in that to prevent the coup d'etat. In the first instance, as a legal means to remain or reestablish the legal order and security, what was practiced in the beginning of pre-revolutionary Europe was the provost jurisdiction, which was active throughout the impressive rebellions related to the harvest of the 18th century. Now, this is note 1. Let's look at note 1. And this is you typically see chapter 3, note 4, right? Chapter 3, go back to chapter 3, and we talk about something that would happen in note 4 about the idea of this. In chapter 3, if you remember correctly, deals with the transition of sovereign powers in the 18th century political thought from the time of the intendants and those stuff, right? It was ultimately executed by the military-inspired gendarmerie, the Privas, the Provost Marshal, the Marshal's Provost Marshal. Those are the Provost Marshal. The Marshals, the Marshal's Provost Marshal. And in its districts, in the so-called Cas de Provolex, the Provost cases, robbery, looting, uproar, and the other kinds of disruptions of public safety. In fact, that the fight against domestic unrest was initially under the jurisdiction and commissarial mandate of an extraordinary juridical activity, one that was bound up with the reduction to a summary procedure, ties in with the development outlined so far, and also with the idea that the existing state supremacy is tantamount with executing jurisdiction, exercising. Sorry, with exercise. In other words, exercising state sovereignty is like exercising jurisdiction. So this idea that exercising state sovereignty is exercising jurisdiction. Sovereignty and jurisdiction interlock in this regard. And the idea was that the original conception was the provost marshals, which was imposing a kind of a judicial office in that sense, extraordinary judicial office, which procedures were mostly summary in that sense, not to restore order in that fundamental sense. This is most evident for the strictly constitutional view of the state, that is, the English view, in which the state is limited to its judicial functions. So therefore, this is why this is very limited. This constitutional view of the state, this English view, in which the state is limited to its judicial functions in a sense. But because the provost's jurisdiction rested on a specific commissarial empowerment coming from the king in England, where a royal commission could not justify the intrusion in the liberties of the individual, such a statement for the extreme summary process against the rebels is impossible to find, in a sense. Under Charles I, the royal commissars received full powers to have both soldiers and civilians sentenced to death outside of ordinary jurisdiction. Even the Long Parliament employed the practice of extraordinary commission. In the United States, the Bill of Rights put an end to this. In a riot, the army could intervene at the request of civil administration. The army could. In other words, the Bill of Rights since 1689, right? The great 1688 Rouge Revolution, the Bill of Rights in 1689, put an end to this in England, right? That the king could do this extraordinary commissions, either the king or parliament. Now this is done in a riot. The army could intervene at the request of the administration. The exordum the extordum to the Mutiny Acts under Queen Anne and King George was phrased in such a way that the prerogatives to declare martial law remained with the crown and its usual authorities, but only at times of war and outside of Great Britain. For example, in Ireland, in other words, outside of Great Britain, outside of the authority of, in other words, this declare martial law, and would remain with the crown in this would only in times of war and outside of Great Britain. Since James I, the article of war allowed the destructions of rebels' private property and gave the commander an unlimited power to pass verdicts of life and death in foreign countries. But this power was limited in the homeland. This is Charles Code, Minister of Justice under the military martial law. Right? But the true legal problem was to justify, in the eyes of the law, the direct violation of life and death of property, and that inevitably, when the army intervened, regardless of whether the army belonged to the rebels themselves or to the neutral third party, the justification given during the uproars and the justification given during the uproars in London in 1780 and frequently pleaded was that civil persons who were found armed were treated as if they were been subject themselves to martial law, but not to the military court. In other words, they weren't subject to military court. They were treated like as if they were that, but not to a military court. They were subjected to the imposing of order, like there was martial law, but there was no military court. It was civil courts were here. Of course, this kind of justice is, in reality, a battle order. Gustav Nost, during his 9 March 1919 session of German National Assembly, Nosta himself characterized his own orders during the Berlin fight of March 1919. Every armed person opposing the troops of the government had to be shot immediately, as an instruction based on martial law. Okay, so therefore, he points to what happened in Berlin 1919. Moreover, it gave no justification for the numerous intrusions in the life and property of natural citizens, which are inevitable when some serious rebellion has to be suppressed with the help of the army. It is for this entire sphere of real military action, which, in the consequence, to be categorized separately from court martial, in other words, military jurisdiction, martial jurisdiction, as a kind of, in other words, separated from court martial or military jurisdiction. I think that's a better word, a martial jurisdiction. That martial law comes into effect. It is a kind of situation outside the law, in which the executive, that is, the intervening army, can act without paying heed to any legal limitations, doing whatever it takes to suppress the enemy in the given circumstances. Despite its name, martial law, understood in this way, is not a right It is not a right or a law at all, but rather a procedure which is genuine, governed by a practical goal, in which the legal control itself, sorry, in which the legal control limits itself to the conditions under which the procedure has come into effect. Uh, commandeering of civil bodies, requests of dismissal, and so on. Period. So therefore, we get this. In other words, he wants to make it clear it's not a law. Martial law isn't really a legal system. It is basically the suppression of law. It is basically the martial law is this rather a procedure to basically say, okay, for the in order to this, which the goal is restoring order and like this, and that the legal control limits itself to the conditions under which the procedure came into effect. That is commandeering bodies, dismissal, requests of dismissals, and so on. In other words, it's not a name. It is martial law is understood in this way. It's not a right, not a concept of right, legitimacy, or a law at all, but a procedure to, okay, in a sense, as legal justification for what happened in situations that fall outside the law. It has been argued that in such cases, all the state powers become impotent and without effect. And in particular, the courts cannot function anymore. So, in this situation, okay, there is a crisis and the courts can't function anymore. It's that, in other words, that during this crisis, during this situation, all state powers become impotent and without effect, and that and particularly the courts cannot function anymore. Then the only functioning power of the state, the army, should become active as a kind of substitute, some rude substitute, and its action should represent both the verdict and the execution, all wrapped into one. Again, Claude, administration of justice. When it's impossible, said when it is impossible, said the late Sir James Mackintosh, for courts of law to sit and enforce execution of their judgment, then it becomes necessary to find a rude substitute for them and to employ them for that purpose, the military, which is the only remaining force in the community. It has been increasingly vital for the Anglo-Saxon sense of justice that in times of war and upheaval, the army function as a substitute for the courts. And therefore, martial law presupposes a kind of ustium, a sensation of public. Let's see if I can find this. No definition. Justice, ustium, kind of justice. Let me see if I can get a better term. To see if I can get something better here. Yeah, ustium is a Roman concept of Roman law equivalent to the declaration of state of emergency. It refers to the state of exception from a state of necessity. In other words, all the courts are closed in that sense. I'm reading it from, in other words, I'm reading it right from, this is a short paragraph, I read it. Justinian, derived from Roman just stadio, is a Roman law concept equivalent to the state of emergency. Some scholars also refer to a state of exception, right? Stemming from a state of necessity. It involves the suspension of civil business, typically including the courts, the treasury, and the senate, and was ordered by the Roman higher magistrates. It was usually declared following a sovereign's death, during the tribute period of interregnum, but also in case of invasion. However, in this last case, it was not as much the physical danger of invasion that justified the the instauration. Okay, in instauration of a state of emergency, the creation of a state of emergency, as the consequence of the news of the invasion in Rome had. For example, Ustium was proclaimed at the news of Hannibal's attacks. The earliest recorded occasion of Ustium being invoked was for the same reason, when in 465 BC panic gripped the city in the mistaken belief in the imminent invasion by the Agrarii. Now, Gambin, justly and progressively came to mean after the Republic, the public mourning of the sovereign, a sort of private thing. So that's a Gambin. I'm not going to go into a Gambin's idea. But okay, this is where this come from, this Ustium. Um, so therefore, that posed a kind of suspension of this. This also happened in an example of the American law of 1795, which, according to Gardner, is still in effect, and which gave the President of the United States permission to call in the militia in the event of a hostile invasion, or when the law was disregarded or its execution was seriously jeopardized, that the unlawfulness could not be quelled through numerous jurisdictions and executive forces. So this is Gardner's James M. Gardner's published in French. So it's the executive power in wartime in the United States, and the Review of Public Law, the Review, 1918, page 16. So. From hostile invasion, in itself, such an appeal is the responsibility of Congress, as outlined in Article 1, Section 8, Number 16, Sections 8, Clause 16 of the Constitution. Here are some cases in which the President resorted to the act, resorted to the law of 1795, hostile invasion, 1812, Civil War, April 1861, Mexican raids, 1619, and the war against Germany, 1917. The executive. This is Gardner's executive power article. All the measures taken at the scene of war are governed by martial law. Hence, in the conception of the law, where the separation of powers is on the whole identical with law and order, martial law means about abolition of separation of powers and a substitution of the brutal command of the military chief. Claude, Administrative Justice, gives the following quotation from Napier and Wellington. The union of legislative, judicial, and executive power in one person is, as the late Sir Charles aptly expressed it, the essence of martial law, or as the Duke of Wellington explained to Mr. Stuart when it was suggested that he should govern Portugal under it. It is neither more or less than the will of the general of the army. He punishes either with or without trial for crimes to be declared to be such, or not to be declared by any existing law or by his own orders. And further on the same page, he quotes Wellington on Article 3 of the War Instruction issued by the American administration in 1863. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil laws and the domestic administration and government, in the substitution of military rule and force of the same, as well as the dictation of general laws. As for the military necessity requires a suspension, subdivision, or dictation. So therefore, in other words, all these things, these institutions, all come under military authority, and therefore, if they're allowed to exist or operate, the substitution of military rule and the force of the same, as well as dictation of general laws, as the military requires necessary for this suspension, substitution, or dictation. Martial law can be declared in riot. 2. declared in riot 2. Okay. Martial law and committee declared in riot 2. If the direct threat of public safety is impending in ordinary law courts are no longer enough. But the president, namely Lincoln, and the military chief frequently resorted to this authorization, often with the Congress's consent, but also without it. The military chief only with the president's consent, and and after suspending normal jurisdiction, they had the rebels judged by the military commission. The famous decision of the Supreme Court, ex parte Mulligan, dealing with such cases in four Wallace Supreme Court reports, rehearsed additional explanation that in case of hostile invasion or civil war, when courts are closed or it's impossible to exercise criminal jurisdiction in accordance with the law in an area effectively dominated by war, the abolished civil authority must be replaced by another power in order for the safety to be maintained in the army and in the society. This is Winthrop, abridgment of military law, right? Martial law designates when one of the spaces is set free for the detailed technical implementation of military operations, in which it was permitted to do what the circumstances demanded. This meant something different from the provost jurisdiction or from the summary court martial. So for this technical decision, martial law was completely different than the provost's action or of a provost jurisdiction, something different from a provost jurisdiction or from a military court summary court martial. The provost law courts are extraordinary military courts in the first instance and of last resort, which decides on criminal acts involving a disruption of public security regardless of whether the criminals are soldiers or civilians. The summary court martial is a summary procedure initially employed only against soldiers and later on extended, like the provost jurisdiction, to the sentence of specific offenses committed in the areas that were subject to the court martial as a result of a former declaration. So look at number 9. This is because the place of jurisdiction of soldiers was considered to be a privileged place of jurisdiction. For the 18th century, see Lung's corpus of military. Yeah, this is a corpus of military law, the body of military law of the Ottoman Empire, and Louise's introduction to war trials in war. Minors, where the combination of legal aspects and practicalities appear in typical form for disciplinary reasons. When these works speak about upheavals and insurrections too, what they really mean is soldiers' mutinies. Okay, in that sense, these military books, these books like this, when they talk about the uprising, that it means soldier mutinies. And 10, according to Joseph II Scupper's court orders of 1788, and subsequently according to the 1803 Austrian Penal Code, Section 500, and then he says, found in about martial law as a criminal procedure. The sources supplied there are used again in Bullink's entries of Standard, martial law, of volume 12 of Rotten. Okay. State lexicon. Yeah, Sumner's a state lexicon of state. Okay. So let's go back to 10 where we finish this second note. Now, when a military chief established under martial law courts for the trial of specific criminal acts, this was in fact a return to legal form. So when the military meter accepts martial law for trials of specific criminal acts, this is in fact a return to legal form. The real core of martial law reveals itself in the state of emergency. So in other words, the real core of martial law this is a concrete action, freed from any legal ramifications, yet serving an aim imposed by the state. So therefore, the martial law is trying to restore order. The order is imposed. That goal is to restore the established, secure the safety of the state, and to restore order. So this, even though there's freed from limitation, it serves an aim that's imposed by the state. It is in its absolute fact, factuality, factuality, factuality. In other words, in its essence, it is not approachable through proper legal forms. So in other words, it's in doing what it needs to be done, doing it in its fact, in what it is. In other words, what its essence, what it is. It's not approachable through proper legal forms. Nevertheless, the semblance of such a form can arise from two angles. From the standpoint of the right, a legal procedure can be so summary that in fact it becomes immediate executive order, and the assessment that precedes the execution is a purely factual nature. So, at one level, it's simply an executive order, a summary executive. In other words, a proceeding is so summary that it becomes immediate executive order, and that its execution is purely factual in nature. It cannot be distinguished logically, normally, or psychologically from the assessment of a soldier who ponders whether a man facing him is the enemy or not. In other words, is this person enemy or not? The soldier too makes assumptions and arrives at a decision, but one cannot say that he has killed the enemy on the basis of a summary verdict that is put into practice. In other words, one cannot say it was a summary verdict that was put into practice at once. From another point of view, the factual one, numerous assessments can prove to be necessary for a method that is based strictly upon facts collected in the form of advice and negotiations. So, from the other point of view, a factual one, numerous assessments can prove to be necessary for a method that is strictly based upon facts collected in the form of advice and negotiations. Hence, these assessments can allow the impression of a proper legal form. So, this collection of information, these assessments, and these things. When a revolutionary tribunal sentences an enemy to death and ponders in advance whether this person is really a political enemy and whether the political interest suggests eliminating him, this is justice only according to a formal concept, which describes everything done by a court of law as administration of justice. In other words, therefore, this tribunal is acting, and it's this, what is it does? In other words, whatever it does, this decision of whether this person is the enemy and does killing in other words, is killing it is his death, eliminating him, in other words, is this person a political enemy? Whether political interest suggests eliminating him. This is justice only in that this is a body doing it, right? This process is a process. In reality, such justice is part of a revolutionary activity. So justice is founded within a revolutionary activity, not within normal jurisdictional activity, not as normal law. The positivist so-called form break, in other words, the positive so-called form breaks down in the situation at stake here. So in other words, the positivist who understands the process of law in terms of the normal situation, in this law, it breaks down. In other words, the pure positivist idea here breaks down. Because why? In other words, this is why does it break down, he says. It breaks down. The positive so-called form breaks down in the situation at stake here. When all legal authorizations of the official bodies have passed into the hands of a military chief, then something necessitated on military grounds, like, say, the destruction of a a home's property, someone's properties, their house, is not an act of expropriation consolidated through the provision that no compensation would be granted, uh, and also perhaps through the immediate one act, in one action, rejection of possible complaints. I'm not going to complain. In other words, I'm doing this. In other words, that the military ground is not doing. He's doing this. He's doing this. In other words, that the authorization of this to do this, make this decision, I'm going to do it. I'm not going to worry about this. Is not an act of expropriation, consolidated through the provision that no compensation will be granted. A measure that is, in other words, and there's also at the perhaps to the immediate una acta, rejection of any complaints, right? A measure that is nothing but faculty, factual, factuality, nothing but factual. I love this word, factuality. Something that is factual, not factual, but something that is factuality. That it's adjective in this verb. A measure that is nothing but factuality. Something a fact. What is factuality? Let's talk about this for a second. Let's see if there's a trans thing here. No, of course not. Um, the the quality of being actual or based on fact. The realm of factuality must be distinguished from the realm of imagination. So it's based on fact. Ah, factuality thus means it's based on fact. It is derived from fact. Derived from fact in that sense. I would have translated it differently. I would have said derived from fact. It'll make reading this much easier. Um, in other words, this question of a measure that is nothing but derived from fact remains inaccessible to legal comprehension and cannot be explained even with the help of the intriguing notion of compound official act, not composed official act. Let's see what this. Okay, let's play explanation. Oh, it doesn't have a composed. Composite official action. In other words, something that is composed by this. The Prussian administrative practice. The Prussian administration assumed such a composed act, which would contain a factual procedure at the same time as a legal provision expressed through fact, and it did so for reasons of of practicality, practicality, practicality of legal regulations on behalf of the citizens concerned in order to establish him or her to gain access to means of legal redress. So this is a means of this. According to Article 132 of Section 132 of Article 2 of the Prussian law on the general administration's day, against the allocation execution of coercive measures, there is in all cases only a complaint in place for something done in a supervisory capacity, whereas against the directive of a coercive measure, the same legal remedies are given as against the directive are given as against the directive with the reinforcement with the enforcement deals and with the enforcement deals in a concrete manner. Now, if the priest uses direct coercion against the will of the person concerned, without having previously given this person a constraining order to capitulate, than the actual creation of a requested condition contains, along with the implementation of the coercive measure, and also the order expressed through the deed for that creation. This means in practice the person concerned must forfeit any legal remedy as a result of the fact that the police immediately acts in advance via the fact. Decisions by the Prussian Administrative Tribunal of March 30th, 1911, also a decision of 24 September 1909 of the Prussian higher courts. So therefore, he points to the German law that shows that way. In a complete translation of in a complete transaction, transition, in a complete transition of the executive power, of course, a means of legal redress would no longer be possible, because the fact would express not only the regulation, but also the rejection of the admissible means of legal redress, so that it would encompass a fabulous wealth of different combinations. The, so therefore, this idea that in fact, once you by making this moment like this, the executive function, by making the executive function at that moment, that it's exercised in that way, there's no possibility. It just negates legal redress. Right? The concept of a composed official act has a strange history, which has not yet been written and can only be briefly outlined here. This practice of the Prussian Supreme Court is only the shallow reflection of a marriage between legal form and fact. In other words, this practice of the Prussian Supreme Court basically makes a marriage between legal form and a fact, right? It was a kind of jurisprudence that politically could have both a conservative, governmental, and revolutionary side. When the idea is still alive, that one can put oneself outside the law through a particular deed, when someone who committed a crime is its post facto an outlaw, an hostis, an enemy, a rebel, or an enemy of the homeland, that person is put outside the law and becomes automatically the object of arbitrary execution. This is well expressed in the old jurisdiction, still alive in the Revolution of 1793, which explains the force of the formula hors de loi, outside the law. Et tout Francos, and every Frenchman is expected to shoot and run over and mistreat. In other words, every Frenchman will be required to shoot and run, attack and run. In the 17th and 18th century, the right to execute immediately is to be, if need be, a runaway who has deserted, a soldier who has shown cowardice before the enemy, or a traitor was justified through the claim that such person was a scoundrel and such an outlaw. So let's go look at 12. To run against, okay, so runs the claim against Tomas. 13, Luvati's, the war process, right? If someone deserts with his wages, he should be outlawed without trial and be considered a criminal and have no freedom, no safety, no escort. The treatment of a felon in English law, one who can be killed without consequences if his running away cannot be prevented by any other means, is an example of the consequence of the idea that one can divest oneself of rights by one's own deeds. Okay, in that sense. Quite frequently, though, one created the fiction of a judgment no sooner pronounced than executed. Again, number 14. Okay, this is text. I'm not going to get into that. From time to time, one could find both arguments being simultaneously used in that sense. They give this double sense that there was that they themselves, that this was ordinary things. From time to time, both arguments in the sense here can be in that sense. In exceptional cases, when someone who was blatantly a scoundrel or a traitor to his homeland was executed on the spot, or when the deed itself is both plaintiff and witness, the elimination of the accused could be in one single fact, uno facto, in one single act, both the sentence and the execution, both the verdict and its carrying out. In particular, in an army officer was entitled to knock down a traitor caught in red-handed, red-handed, in the act. Right? Fragrantly, immediately, fragrantly, in the act of something. Um, at the same time, this justification, when initial, which incidentally was also used to defend the killing of Wallerstein, operated with a concept of outlawry and one of composed official act, which any citizen could undertake in his or her capacity as an occasional organ of the state, to employ the coys used by Jelinek. So, okay, what does this go back here for a second? Note 15. In the pleadings, in the 1634 pleadings, the detailed and thorough report of Friedland and his followers' abhorrent treason, it is stated, despite giving all reasonable rights and above all the laws of the Holy Roman Empire, they must be suspended in such criminal cases of treason and permanent high treason against the majesty in particular, which cannot be denied, and where the case cannot have been easily prosecuted because of the delay. The Commonwealth would have been endangered. The state, the Reich would have been endangered. And no other processes or judgment was possible than the execution itself. Um, this is Latin, which is what which here is like a sentence. Therefore, it is here like a sentence. Everyone is therefore entitled to undertake the execution of a public enemy of the motherland. Um, as an answer to this, see the interesting reply in the um, relation from Parnaso. It would be against all international law to deploy subordinates as prosecutors, judges, and executioners of their superiors. Less charge and execution would be simultaneous in the fact the execution would have preceded the charge. In that sense, this is the response to the answer to this question, right? So I'm just making sure. Okay, well, this is how naturally the revolution could not. The revolution could make use of this concept just as much, and it could allow its enemies to receive justice in the form of getting shot. Right. This is on 29th March 1920 in the 150th session of the German National Assembly. Gebler, the defense minister of defense for the Reich, communicated the proclamation made in Duisburg on 25th March by the Communist Revolutionary Leadership. The proclamation stated, "In maintenance of order and security is conducted by Revolutionary People's Militia. Whoever is Whoever is seen engaged in activities such as robbery, looting, theft, or usury should be sentenced by court-martial will be sentenced by court-martial and shot." The Minister of Defense of the Reich comments. Here you can see the new constitutional law. One might think that in this case the execution precedes the sentence, but this may but uh, but this may have been meant simply as a combined official act, indistinguishable from an unauthorized assumption of an authority. since one cannot distinguish between the immediate execution and the murderer. In the darkness of a juridical night composed of official acts, all colors are black, and the act too quite possibly entails, among other things, an immediate new appointments to some office. See Friedlander's The Institution of German Administrative Law. Hence, the natural rights aspect of the problem can still remain unresolved. That is, overall, whether having a legal person is compatible with a general state of emergency and with the war of each of all against all. In other words, in other words, hence the natural rights aspect of the problem still remain unresolved. That is, whether having a legal position is compatible with the general state of emergency and with the war of all against all. From a legal perspective, it is critical that such conceptions. From a legal perspective, it is critical that such conceptions of the via fact of the fact. The, okay. Proceedings in the way of fact, something in the way of fact, proceedings by the way of action, or proceedings by the way of action, proceeding by the way of fact, ignores precisely what is essential to the right, its form. In other words, it's critical, from a legal perspective, it's critical that such a conception of this proceeding by way of fact ignores what is essential to the right, its form in that sense, right? Its form is just, and it says the comment by Schleisham in his The Form of the Kriegs. The forms of declaring war and investigation into international law is splendid. The emphasis rests on the form of the declaration. Whoever has killed a person cannot claim that it was a duel in which the first stroke was the challenge to the duel. In other words, the first stroke was a challenge to the duel. The question of the form of a declaration. It can't be based on the principle that, like he says, it has to be declared and then there takes to be action. It can't be for a duel. There must be a challenge. The first strike does not constitute a challenge. Right? The form is important. The form by which it is, but this destroys it. From a legal perspective, the concrete fact kind of ignores the form. However, because of a legal interest, especially in martial law, a whole range of formal requirements are being sought. Not in the fight against the foreign enemy on the battlefield or in the colonies, but in the fight against the political enemy at home. That is, when the action of the state is directed against its own citizen. In other words, the legal interest of this of martial law ranges from a requirement is being sought not in the question of foreign enemies or over the colonies, but only eternal home when the fight is the political enemy at home, right? Against, in other words, when the action of the state is directed against its own citizens. Such formal requirements never deal with or pertain to the action itself, but only the premise. In other words, the formal requirements never deal with what is to be done and the actions being done, but what the premise is, right? This important distinction derives from the separation between two entirely different types of legal regulations. In one, the context is described with attention to the minute detail. So one is the content of what is to be done of the law, the content of two distinctly different types of legal regulation. One, the content of what is described as with detailed thing, complete minute detail, right? In the other, only the premise is treated this way. In other words, the end, the premise, what is to be done. Whereas the normal law is not only what is to be done, but also how it's done is addressed. Okay, That's what he says. The normal way is that every detail, every minute detail of how it is to be done, what is possible, what is not possible. No, and the other thing in this other condition, regarding this martial law, what it seems to be the other thing is, in other words, and the other, only the premise is treated this way. Any legal standardization involving restrictions from the standpoint of unconditional efficacy. In other words, any legal standardization involves restrict. In other words, any legal standardization, he argues, Schmitt argues, any type of standardization of legal things here involves restriction of the standpoint of the unconditional. In other words, it tries to limit and constrain through. In other words, legal standardization makes constraints and procedures and rules that need to be followed. That limits. These are limits, right? And they make restrictions on the standpoint of unconditional efficiency. This word here, right? This absolute practicality. In other words, it's an absolute practicality. The limitation of military implements under international law on the basis of war conventions, for example, the prohibition against certain types of weapons, demonstrates most clearly the antagonism between legal standardization and the kind of situation that would be real life condition against that would satisfy real life condition. In other words, this is the idea that certain weapons can't be used. But if it's survival, that was if you're going to. In other words, this is the problem of these international standards. These weapons cannot be used. But if you're but this is the only access, the only way you can survive is to use this. Then you'll use it. This is what the silly aspect of this is, that the factual situation overrides the legal constraint. That these legal norms, as Schmitt is arguing, these legal norms are just artificial constraints in survival, in that sense. In other words, any legal standardization involves restrictions on the standpoint of the unconditional effect and efficiency of it. Again, an absolute practicality. The limitation of military implements and initial law on the basis of convention, like the certain types of weapons, demonstrates the antagonism between these legal standardization and the situation that real life situations that satisfy real life situations. Now, the intention to settle legally the deployment of military powers against citizens of one's own state can lead to an indefinite postponement of the use of such resources. The intention would be to create further guarantees that the state of emergency is only recognized when it has taken place. In other words, it can only. In other words, it's after the fact. No preemptive addressing of it in that sense. In other words, very interesting things. Ernstfall, emergency, the state of emergency, Ernstfall. The intention would be to create further guarantees that the state of emergency is only recognized when it was taking place, right? If you strain it, you can't do this and this until you can do it, postpone it to an indefinite postponement of the use of such resources, right? But suppose you come to use these extreme reserves, be it only once. In short, if an effective measure needs to be taken, there comes to an end the legal regulation about the context of this very measure. In other words, you must do it. You must exercise it, and that's the end of this measure. Here, standardization has to limit itself to describing the premises on which the state of emergency may be said to occur. It cannot limit how it is being done. Now, this point is the legal standardization can only address the premise when a state of emergency is. What defines it? What it is? When it is? Okay, not how it is to be resolved. Because what can be done to resolve it? If it does that, then it goes too far. It then goes to the point of actually endangering the system. Okay, the difference is the standardization can only work at the level of at the level of the premise, not the level of the means that is being done. The law then either defines a fact of the case that offers clearly defined concepts, concepts captured with the maximum factual accuracy, or else it attempts to offer a guarantee through some kind of separation of powers by allowing that institution an institution different from the army decides what constitutes a prerequisite for the state of emergency, namely one that carries out the action, namely the one that carries out the action effectively. In other words, another body, not the army. The army won't decide this. It's going to be another body. Nevertheless, the separation of responsibility falls in the case of emergency. Nevertheless, the separation of responsibility fails in a case of emergency. So therefore, they can do this, but that will fail in a case of real emergency. This creation of that body would take too much time to do that. For analogy in self-defense, when the conditions are met, that is an illegal attack, and now it is permitted to do anything it takes to counter the attack, and there is no specification in the legal statute about the context of what is allowed to happen because the law does not name the actual measures. It only advises what is necessary for defense. So therefore, this is the problem. This is like, for analogy, this is the analogy he's doing this. You make this other way. For analogy in self-defense, when the conditions are met and that there is a legal attack in the now, it is permitted to do anything it takes to counterattack. And there is no specification in legal statutes about the contents of what is allowed to happen because the law does not name the actual measures. It only advises what is necessary for defense, right? In the same way, once the conditions of setting up the state of emergency has occurred, the actions made necessary by the concrete circumstances occur too. So that once the condition setting up the state of emergency has occurred, the action made necessary by the concrete circumstances occur too. The analogy goes further. This is making an analogy. It is in the essence of the right to self-defense that its conditions will be determined through the deed itself. It is the essence of the right of self-defense, that the conditions will be determined through the deed itself. What is being done to it? How am I defend? What is being done to me, and how can I defend myself? Hence, it is not possible to create an institution that could prove legally whether the conditions for self-defense obtain or not. In other words, there's no way you can create a body that could prove legally whether the conditions of this is Schmitt's would be attack of once you have self-defense. It's what are the conditions of self-defense? You have to be threatened. You have to feel threatened. Therefore, this is going to be hard to prove. In other words, it's going to be hard. Create an institution that could legally prove this, whether the conditions for self-defense obtain or not, in the formal sense, not in the after the fact, but prior to exercise it. In other words, this is the exercising of doing the defense, not the judging of the act after the fact, but judging it while it's just as it's about to happen. In the same way, a real cause of emergency, the one who acts in self-defense cannot be differentiated from the one who decides whether there is a case of self-defense to answer. In other words, in the real case of emergency, the crisis or that, it cannot be other party can do it. It has to be the same party. The person who's going to respond, because it's because the one who decides whether there is in other words, the one who acts in self-defense cannot be differentiated from the one who decides whether there is a case of self-defense to answer. These positions are not to be considered two legal standpoints of universal scope. These positions are not are to sorry. These positions sorry, I'm incorrect. These positions are to be considered two legal standpoints of universal scope, with which sorry, my eyes I'm reading this badly, sorry. With the help of which the development to follow will raise above what is historical and contingent. In other words, the logic of these positions that he's talked about here, what the conditions, these two analogies that he's held, right? That he's just in that above paragraph. These two positions are considered two legal standpoints of universal scope, with the help of which the development to follow will raise above will raise above what is okay. This is a powerful translation. I think there's something wrong here. With the scope of which the development to follow from the above will raise above what is the historical. In other words, he wants to raise what is the legal scope, what is the legal standpoint versus the merely historical and contingent. So, in other words, the development to follow will raise above what is historical and contingent. In other words, okay, let's do it. So, in other words, with the help of which the development to follow, what is to come, will raise above what is historical contingent. So, therefore, this is what is the next paragraph, the next section, which we're going to stop here. What we would continue now, the following part will lead us from help us get us above what is historical contingent, get to the formal, and that's how to get to the thing. So, if you have any questions, comments, it's been very difficult reading. I understand it's frustrating in that sense. If you have any comments or questions about what has been raised here, and you want further elaboration, or you want as you go read the text, or you got comments, please put them here. I will respond to them. Maybe make a video response if it needs to be. I might respond by text, but if if it does require a longer form, I might make a video to this. Another thing we can do is, if you like the thing, like it, hit the like button. Hit the like button. Share it on your social media. Share it with your friends. Now, if you didn't like it, you can always hit thumbs down. You could always hit thumbs down and say, no, I didn't like it, but say why in the comments. Maybe we can learn from you in that sense. This is the purpose of this. What this is being done. What you didn't like, what you didn't understand, or you thought was I did wrong, I misunderstood. And I do have dyslexia. You can see my dyslexia with these words going back and forth. I should maybe make these bigger, but if I do that, that'll be longer, difficult more to do. If you have also, if you've not subscribed, and you please subscribe. Encourage others to subscribe. Reach out to friends to say, "Hey, you might find this interesting." Subscribe. Another thing you can do is, okay, if you want to follow me on social media, my social media links are below. If you want to follow my academic work and see check me out as a scholar, you can. Underneath the social media, there are the academic social media links. And then, if you want to help me to deal with it financially, it's expensive. It's growing better, and it'd be nice. We don't have a chip. I mean, we're not big enough of a channel to get the kind of like a chip, a live chat or tip jars. Like a tip jar, so you can throw your pennies at me. It'd be nice. But it's not there yet. Therefore, the only way you can help is through Patreon or Subscribestar, or by buying one of the books listed below through Amazon, or through other online source, or through your bookstore. The best book to buy online is the Lulu book, because if you buy the Lulu book, I get a bigger share of the profit. You buy directly from Lulu in that sense. You buy directly from Lulu. Okay. Well, take care. That's it. Remember, Fridays are always going to be live chats or messing arounds or book things. We're kind of trying to catch up with the things. So this is probably on a Thursday, and then if we have going to have four more sections of this. So this is the first section, four more, and then we're going to probably finish up the thing. So next week will probably be the last week of Schmitt's Dictatorship. Well, take care. See you later. Bye bye. Have a good day.